school district in sort of a general counsel capacity. And I'm joined this evening by my colleague, Sheila Vasantharam, who is going to offer a brief presentation on the trustee residency and vacancy process, and speak a little bit to kind of some of the most recent conversations that have been had around the matter, and perhaps field any questions that you all might have after that presentation. So with that, maybe I'll introduce my colleague.
Good evening, board members and committee members. I'm here today to present on trustee residency and the board vacancy process. If we have the next slide, please. Under California law, school board trustees must be residents of the districts that they are elected to represent. California law defines residence as the place where one remains when not called elsewhere for labor or other special or temporary purpose. And under California law, an individual can only have one residence at a time. Courts look at multiple factors to determine an individual's residence. The most critical element for determining an individual's residence is his or her intent. Where does he or she intend to make her residence? Courts will also look at the individual's physical presence. Have the next slide, please. As well as additional elements, including where the individual is registered to vote, what their mailing address is, where their tax returns are filed, and where the individual's automobile is registered. Next slide, please. A member of the public that believes an elected official does not meet residency requirements and seeks to remove the individual must first receive approval from the California Attorney General's office to initiate a quo warranto action. The Attorney General's office looks at the same factors that courts do in determining an individual's residence and has denied leave for a quo warranto action where the elected official is likely to meet the residency factors. And it is very unlikely that Attorney General's office would approve the initiation of a quo warranto matter where the residency factors are met. And we're specifically here today, next slide, please, due to concerns that have been raised regarding Trustee Murray's current residence. And I just want to go through the facts and why the county attorney's office believes that Trustee Murray's residence remains the same. Trustee Murray has only temporarily relocated because of her landlord asked to complete work on her residence. She's expected to return to her residence within 30 to 45 days. She and her landlord have agreed to terms that will allow her to sign a new lease for the residence upon completion of the work. In addition, Trustee Murray has maintained her address, specifically her voter registration, her mailing address, and her automobile registration remain at the address in Trustee Area A. And so it is our opinion that under the totality of the circumstances that we've been presented with, Trustee Murray's residence has not changed, and she can continue to retain her position as a trustee for Trustee Area A. And this is based on current case law and Attorney General opinions that we have reviewed. And lastly, for the next slide, please. I briefly wanted to review the vacancy requirements for the board. A vacancy on the governing board can occur for any of the following reasons: a death, an incapacitation, a resignation, excessive absences, conviction of a felony, or a board member ceasing to be an inhabitant of the state or resident of the district. Here, none of those events have occurred. Based on our analysis, Trustee Murray continues to be a resident of Trustee A, and there's no vacancy that the board must manage at this time. Thank you.
I wanted to add just one other fact to the matters that have been shared, and that is that we understand actually that Trustee Murray anticipates returning to her residence here within the next couple of weeks. So it looks like the work that had been the cause for needing to temporarily relocate is actually in the process of getting wrapped up. So, with that said, I mean, we're obviously, Madam President, ready to field any questions that board members might have for us, or elaborate on anything you might want elaborated on.
Wonderful. Thank you. Any question, Mina?
Yes. There are several questions, and basically when the community where Trustee Murray resides District A, have been asking about the timeline. When did it begin and when will it end? It has been upwards of over 60 days beyond the 45 days that we kept hearing about, and the board received official word from her. And at this time, we're approaching over 60 days of her, but I don't have anything official. The board has never received anything formally. There's in her communication, there has been word of a agreement with the district. And so that needs clarification for the doubts that the community is having. Now, that's all I can say at this time. We only know what the California School Board Association allows us, which is one of two conditions when a board member can be granted extra time away from her district or his district, which is being in the military, which is 6 months, is allowed to be outside the state. Another one, the second condition would be a quo warranto, which it calls for something having to do with health issues. Now, I don't see anywhere in the California School Board where they talk about intent. Now, intent is a very open-ended situation, and I would like to hear your opinion about this as it relates to this situation, because as I see it, it can't be open-ended. And we as a board need some sort of guidance at this point, which I feel we have not received. Thank you.
Thank you, Trustee. I'm sorry you feel that way. I feel that we have actually tried to provide very clear legal advice with respect to the matter. Kind of a lot to unpack in the comments. I'll see if I can work my way through it. Actually, as my colleague had pointed out, actually intent is really kind of the key factor when you're looking at ultimately whether or not there's been a change in residency. And what ultimately the case law says, and what the California Attorney General sort of looks at when it considers the quo warranto sort of matters or the applications to file a quo warranto case, as you were referring to, what the court really looks at is, and the AG looks at, is whether or not there's been a coalescing of kind of fact movement, so to speak, and an intent to take up a new residency. You can only have one domicile, one residence at a time. And you can't, frankly, be deemed to have vacated your current residence until you've taken up a new one. And you don't take up a new one until you've had a coalescing of intent and actual movement. The bottom line here, as I have seen it, and then frankly, that's the reason we opined the way we did, is that there has been no intent on the part of Trustee Marie to take up a new residence. So she retains her current residence. That's kind of as simply as I can put it. I don't know if that's completely responsive to your question, but I don't. Maybe there's something else that I can say to elucidate what your concerns are.
Well, I didn't hear you say, well, how long should we wait? Because as I understand that it is a remodel. Sometimes these things go on for months, years, and then we're coming up into the election season. So those are things that are a concern to the board at some point, whether or not in the California Elections Code says that at the time you are up for re-election, you need to be at the place where you are staying, one residence at a time. So I don't understand where this gray area would come in. So I was hoping that you would give us it's some sort of guidance on this, but I don't see that there is much.
Well, I don't think the case law, frankly, I'm quite certain the case law doesn't prescribe a specific time frame in any particular case. I mean, it could be 30, 60, 90, 120 days. The law, in fact, doesn't set forth a specific timeline. What the law does say is that you don't take up a new residence until you've essentially relinquished your prior residence, and you don't take up a new one until you've had both an intent, coupled with action with respect to a new residence. So I think you're right. I haven't given you a timeline because the law doesn't prescribe a specific timeline. It's all based on the circumstances of a particular case.
One last comment.
Yes, ma'am.
When you were determining your opinion to the board, were you able to see any document submitted by Trustee Murray so that you could verify that she indeed has some sort of relationship or some statement to back her up? Or is this just something that's by implication and that we really don't have any substantiated or any kind of document, saying that she will indeed return to this, her old residence?
I may be misrecalling. I'm sorry. So I'm going to go out on a limb here. I believe there may have been actually a letter from a property owner indicating that the understanding was that Trustee Murray was going to return to the residence once it was remodeled. I believe that's the case. So I guess that's what I'd say. And the other thing I'd say is that there's sort of other facts that are relevant to the analysis, including the fact that that Trustee Murray did not change her address with the DMV. She didn't change her address with respect to the receipt of mail and factors like that. So we looked at kind of a range of things, the kinds of things that the Attorney General and the courts tell us we should look at in these kinds of circumstances.
Are you representing Trustee Murray in this concern, or?
I was advising the Board of Trustees of the district.
Okay, thank you.
Any other question from the board? No? Yes, please.
With a question. Thank you so much for your presentation this evening. As I was listening to Trustee Richardson speak this evening, I did hear her reference the California School Boards Association, and I noticed the dichotomy with what you were referencing, which is case law.
Sure.
And so, am I correct in understanding that your opinion and the guidance that you have provided us is based on what has taken place in the court and just past practice, as opposed to guidance that typically comes from California School Boards Association?
Thank you. Yes, we definitely were looking at court cases, advisory opinions from the California Attorney General's office. I do know that the CSBA oftentimes publishes information for school board members to consider. Sometimes the information is abbreviated. Sometimes it's contextual. I certainly wouldn't take issue with the things that CSBA publishes. We reference them all the time. I think that, and frankly, I don't have in front of me currently the particular thing that CSBA might have published with respect to board vacancies. I know they publish a very helpful guide with respect to filling of board vacancies, and we look at that all the time. But we certainly look comprehensively at the case law and the Attorney General opinions in this area.
Thank you for that clarification. I appreciate it.
So if somebody wanted to remove me from office, they would have to go to the California Attorney General and they would have to file for quo warranto. Is that right?
Yes, trustee. The process, and Sheila, you'll make sure I get this right, but the process would be to apply to the California Attorney General for leave to file a quo warranto action. And that's a Latin term for, I'm not even quite sure what, but basically the idea is that you would get leave from the California Attorney General to file a suit in court to remove a trustee. I frankly am quite confident that we're sound in our opinion that that standard has not been met and that the Attorney General would not grant leave in this particular case. We've looked at a number of cases that are analogous, and frankly, a number of cases that are, I don't even want to use the term egregious, but where the facts are frankly more certainly beyond the facts we'd be talking about here, where the Attorney General has denied leave to file a quo warranto action.
And that would take more than the 2 weeks that I'm going to be out of my house because I'll be moving. back in the next-
Absolutely the case.
Okay, thank you.